Section 20, Legal Hotline Q&A, Part 4. Introduction. Agency questions never stop. Throughout this course, we have discussed agency disclosure, buyer representation, implied agency, procuring cause, limited dual representation, and the many situations that can create confusion regarding agency relationships. One of the biggest lessons we have learned is that agency law does not exist in a vacuum. Real estate transactions often present unique situations where agents must determine whether they are acting as a principal, as an agent, or whether a duty still exists after a transaction has ended. This section examines several additional legal hotline questions that demonstrate how agency principles apply in real-world situations. While the facts may be different, the underlying lesson remains the same. Understanding the limits of agency can protect both the client and the licensee. When an agent is acting as a principal, one of the most common misconceptions in real estate is that a broker is automatically responsible for everything a licensee does. In reality, the answer often depends on the capacity in which the licensee was acting. The legal hotline discusses a situation where a real estate agent personally owned an apartment building and sold it as a for sale by owner without listing the property through the brokerage. After closing, the buyer discovered significant roof and plumbing problems and attempted to hold the broker responsible for the alleged non-disclosure. The answer was that the broker would probably not be liable if the agent was acting solely as a principal and not as an agent of the brokerage. However, the outcome could change if the agent created the appearance that they were acting on behalf of the brokerage. Examples might include using brokerage business cards, meeting clients at the brokerage office, or conducting business in a way that suggested brokerage involvement. This situation highlights the importance of understanding the difference between acting as a principal and acting as a licensee representing a client. Real-world example, the agent-owned property. Imagine an agent owns a rental home and decides to sell it independently. The agent advertises the property as a for sale by owner and negotiates directly with prospective buyers. If the agent clearly acts only as the owner, the brokerage may have little or no involvement. However, if the agent starts handing out brokerage business cards, meeting buyers at the brokerage office, or presenting themselves as acting through the brokerage, buyers may reasonably believe the brokerage is involved. This concept is known as apparent authority, and it can create liability where none was intended. When does a broker's duty end? One of the most frequently asked agency questions is whether a broker owes ongoing duties to a client years after a transaction has closed. The legal hotline addressed a situation where a brokerage represented a buyer in a transaction nearly 2 decades earlier. The buyer later became involved in a title dispute involving an easement and demanded that the brokerage assist in resolving the legal issue. The answer was no. The course material explains that absent an agreement to the contrary, a brokerage's fiduciary duties generally end when the transaction closes. The Arizona Court of Appeals addressed this issue in Coldwell Banker Commercial Group, Inc. versus Camelback Office Park, recognizing that once the agency relationship has been completed, the broker's fiduciary duties generally terminate. This is an important reminder for agents. While professionalism and customer service may continue long after closing, agency duties generally do not. Knowing when a matter becomes legal advice, the title dispute example also illustrates another important agency principle. The buyer wanted the brokerage to help resolve a legal dispute involving easement rights. However, interpreting easements, litigating title issues, and resolving legal disputes are functions that belong to attorneys, not real estate licensees. Throughout this course, we have repeatedly discussed the importance of staying within your area of expertise. One of the best ways to protect clients is knowing when to recommend professional assistance. Good agents know when to stop being the expert in the room. Can an agent terminate representation? Another legal hotline question involved a buyer who was discovered to be a registered sex offender after the agent had already been showing homes and assisting with the transaction. The question became whether the buyer's agent could immediately terminate representation. The legal hotline explained that registered sex offenders are not a protected class under fair housing laws, and the agent was not required to continue providing representation. This situation reminds us that agency relationships, while contractual in nature, are not always permanent. Depending on the terms of the agreement and the circumstances involved, representation may be terminated. Agency versus ownership interests. Another interesting scenario involved a property owned by an LLC. One of the LLC members happened to be a real estate licensee working for Brokerage A. The LLC itself, however, was represented by a listing broker from Brokerage B. A buyer's agent from Brokerage A presented an offer. Was the buyer's agent a dual agent because a member of the LLC worked for the same brokerage? Probably not. The legal hotline explained that simply being a member of the LLC did not automatically make the licensee the representative of the seller. The LLC was represented by Brokerage B, meaning the buyer's agent from Brokerage A was not automatically involved in a dual agency situation. This example demonstrates why agency relationships must be analyzed carefully rather than relying on assumptions. Compensation requires agreements. The legal hotline also addressed a compensation issue involving a net listing that was not placed in the MLS. A buyer's broker wanted to know whether compensation could still be earned. The answer was yes, provided the buyer's broker entered into a co-brokerage agreement with the listing broker specifying the compensation arrangement. The legal hotline recommended that such agreements be in writing whenever possible. This ties directly into our earlier discussion of procuring cause and buyer representation agreements. Compensation should never be assumed. Clear agreements help prevent future disputes. The read form is not required by law. One of the most surprising legal hotline questions involved the real estate agency disclosure and election, READY form. Many agents believe the READY form is required by Arizona law. It is not. The legal hotline explains that while agency discussions should occur at the beginning of the relationship and should be confirmed in writing, Arizona law does not specifically require the use of the READY form itself. The READY form was created by the Arizona Association of Realtors as a tool to help agents explain agency relationships and document those discussions. However, many brokers require its use as part of their office policies and procedures. This distinction is important because it reminds agents that the law requires agency disclosure and understanding, not necessarily one specific form. The big lesson: the legal hotline examples in this section demonstrate that agency law is often about understanding limitations. Brokers are not automatically responsible when agents act solely as principals. Agency duties generally end when the transaction is completed. Real estate agents should not provide legal advice. Representation can sometimes be terminated. Ownership interests do not automatically create agency relationships. Compensation should be clearly documented. Most importantly, agency disclosure is about communication, not simply paperwork. As we have seen throughout this course, the agents who avoid problems are the ones who understand their role, recognize their limitations, communicate clearly, and document their relationships from the beginning. Online discussion questions. Question 1. Why might a broker avoid liability when an agent sells their own property? Answer: because the agent may be acting solely as a principal rather than as an agent of the brokerage. However, apparent authority could create liability if the agent appears to be acting on behalf of the brokerage. Question 2. When do a brokerage's fiduciary duties generally end? Answer: absent a separate agreement, fiduciary duties generally end when the transaction closes and the agency relationship has been completed. Question 3. Is the READ form required by Arizona law? Answer: no. While agency discussion should be documented in writing, the READ form itself is not specifically required by Arizona law, although many brokers require its use.